got us going?
Yeah, actually not.
Okay. We are on the record in the cases of originally filed as Wesley, State of Nevada versus Wesley Glenn Dick. Mr. Dick has since informed the court that he wants to additionally go by his Native American name, which is, as I understand it, is Quassa. So we're going to go forward under Quassa Wesley Glenn Dick Jr. for the rest of this, or these cases. And the cases are, if I can get down to it. Case number 12CR013 and case number 12CR019. Is that correct, Ms. Clerk?
Yes.
Okay. Today is the day set for both a prelim and a trial in this matter. My understanding is that the parties have had some issues regarding discovery and witnesses. First off, I'd like to ask the defendant, have you asked for any discovery in this case? Do you know what discovery is?
Yeah. Yes, we did.
What did you ask for?
We asked for discovery 2 weeks ago or so.
Okay, by phone call or how?
Facts.
By fax. Did you receive a fax from the defendant?
Your Honor, we received a fax last Monday before we came here for the
Okay.
oral arguments.
Did it ask for discovery?
It asked, it was from a non-Nevada attorney
Okay,
asking for that, and so we were here on Monday to,
okay. Was there anything from Mr. Dick asking for discovery?
not that I'm aware of, it was the, let's double check really fast. There could have been something Friday we received. Let's see here.
Prior to Friday, was there anything?
No,
I asked Ms. Spotterbear to do it for me.
Okay. You asked that, though, after you were incarcerated, probably, correct?
No, before that.
Before that, okay. But you'd have no knowledge of her having actually done that other than possibly? You have no knowledge of her having done that other than possibly through an attorney out of state?
I have the papers asking.
Can you find where you asked for discovery in your papers?
The motion was received by the Austin Justice Court on September 30th.
Okay. That's the, okay. And we faxed all that stuff correct to the district attorney's office?
I would imagine at least.
Can I, if you would, can you show the sheriff where it says you're asking for discovery? Can we unlock one of his cuffs? Whichever one he is, right-handed or left-handed,
Which hand did you do both?
or both of them is fine. I'm not, the reason he's in custody mainly, Sheriff, is because of the failure to show up. He was a bit unruly, but that was verbally unruly. I'm not that afraid for my physical safety. clerk.
Hmm?
Is this something that you fax to the DA?
Yes.
Okay, would you show that to the DA? This is the second page. Do you recall getting that document? Ms. Elquist?
Yes, Your Honor, we received the fax from the court.
Okay, you notice where it says on there, it does say a motion for discovery?
Yes.
Okay. Is there some reason that you didn't send any discovery to the defendant?
Yes, Your Honor. Let me just give a little bit of background here so I can make the record clear. We filed the complaints in June, and then Mr. Dick filed a motion to dismiss based upon jurisdiction in August 12th. Oral argument was set for last Monday, September 30th, on the issue of jurisdiction. I filed an opposition to that on August 26th. I sent it to Mr. Dick, certified mail and regular mail, and it was returned, the certified mail.
Did that contain discovery or just the response?
No, that was just responding. At this point, there was still the issue of if he was gonna have an attorney or not, or represent himself. So, on Monday, when we appeared for the oral arguments on the jurisdiction, I have the discovery here for his signature if he was gonna represent himself. I was wanting to request of the court to make sure there was a...
That's enough. I get the gist of it. Your grounds for not providing discovery I find valid, and you are excused from having done that. Mr. Dick caused his own problem by not being here. So the lack of discovery is not going to be grounds for any sanctions in this case. But, let's see, I guess, let's go to the jurisdiction. I'm gonna put some things on the record. We're not gonna argue it. I'm gonna try and get through this as rapidly as I can today.
Okay.
Mr. Dick's arguments have been that we are without jurisdiction as the state of Nevada, even though it is my understanding, at least all the arguments to date have been along the lines of that Mr. Dick was, and the probable cause showed that he was picked up for the alleged violation outside of any Indian reservation. He was on the public lands of this state and not in an Indian reservation. That's critically important because the state statutes provide, I believe it's 502.280 for Native Americans or to be able to fish and hunt on reservations without paying for a fishing and hunting license.
Can I see that statute you're talking about?
After we're done, NRS 502.280, resident Native Americans exemption from fees for hunting and fishing licenses, application for free license, requirements for big game tags. Directly on point to whether or not we have jurisdiction is a Nevada case out of Fallon, of all places. What a coincidence where Mr. Dick is from. It is from the Supreme Court of the United States, and it is called Nevada et al. Petitioners versus Floyd Hicks et al. It is 121 S.CT.2304, or Supreme Court Reporter 2304. And it is, the case number is number 99-1994, was argued March 21st, 2001, and decided June 25th, 2001. In that case, the United States Supreme Court invalidated the attempt by the Fallon Tribal Court to stymie the efforts of state officials who were investigating the taking of of desert bighorn sheep at the defendant's, at the respondent, Mr. Hicks' residence on the Fallon Indian Reservation. And the Supreme Court held in a unanimous decision that the tribal court could not handle federal civil rights cases, and that they had nothing to do with game violations or alleged game violations that occurred off the reservation. Those belong to the states. I'm not going to go into all of it. I've given you the citation. You can read it on your own time.
I believe there's more to that case.
There may be, Mr. Dick, this isn't a negotiation. We're moving on. The other part of the court's reasoning is that under a variety of early cases in the United States, in the U.S. Supreme Court, and I'll just quote from one of them. It goes as follows. At common law, the title and dominion in lands flowed by the tide water were in the king for the benefit of the nation. Upon the water were in the king, upon the American Revolution, these rights charged with a like trust were vested in the original states within their respective borders, subject to the rights surrendered by the Constitution to the United States. The new states admitted into the Union since the adoption of the Constitution have the same rights as the original states in the tidewaters and in the lands under them within their respective jurisdictions. That is from Phillips Petroleum Company versus Mississippi, 484 U.S. 469, 473 to 474, 98 L.Ed. 2nd, 877 at 844. 108 SCT at 891, a 1987 case quoting Shively versus Bowlby 152 U.S. 1 at 5738 LED 331 at 352 and 14 SCT 548 1894. The reason that matters is this quote. When the revolution took place, the people of each state became themselves sovereign, and in that character hold the absolute right to all their navigable water and the soils under them for their own common use, subject only to the rights since surrendered by the Constitution to the general government. That's Martin versus Waddell's lessee, also known as Martin versus Waddell, 41 U.S. or 16 PET period, 367, 410, 10 LED 997, at 1013, an 1842 case, quoting Johnson and Graham's lessee versus McIntosh, also known as Johnson versus McIntosh, 21 U.S. 8 Wheaton, 543, 5 at 595, and 5 LED 694, which is from 1823. The reason that the water's under the state, I just knew about that because I had to deal with a case having that. The reason that matters is that all of the incidents of sovereignty from the Crown went to the states. Only the ones granted by the Constitution went forward. One of the incidents of sovereignty is the power over game.
Could you repeat that?
The power, one of the incidents of sovereignty that went from the Crown is to the people of the states is power over wildlife, over game.
No, about the crown,
The English crown.
the Queen of England?
Well, at that time, it was the king. It was King George
We don't
III,
have no
but
kings and queens here.
I understand that. This is how this country came to be. So, those incidents of sovereignty went to the states. There has been a dichotomy, and you can see that in the reasoning without them being explicit, of Nevada v. Hicks. And in, I'm trying to remember the 1976 case, but there's somebody versus dealing with the Wild Horse and Burro Act. You can look it up later. It's in New Mexico, but I can't remember who it is. It's somebody versus New Mexico. In that particular case, in the United States Supreme Court, it was held that the United States had authority over the wild horses and burros because they were on public lands, so they had the right to regulate them on public lands. That did not, however, take away from the state's right in the animals. Similarly, in Hicks, we see that the tribe has jurisdiction when the hunting occurs on tribal lands. Okay, so you can see where they're doing their dichotomy, if you know those two things, that the wildlife belongs to the state, but if it wanders off onto either tribal or federal lands, then the sovereignty under which those lands are has an interest in them, and consequently, under various treaty rights and statutes of the United States, the wildlife belongs to that particular sovereignty for purposes of hunting. My understanding of the underlying facts of this case, and of course we haven't had any testimony, I'm going by the police reports, is that this was pronghorn antelope that were taken off the reservation, as in the case of Hicks, and consequently, as in Hicks, this court has jurisdiction. Consequently, this court planned, let me add more to that. That's all I'm going to say on the jurisdiction issue at this point.
I'd like to say something.
It is, no, you may not. It is the holding of this court that the court has jurisdiction over this case and over any future case that may occur in this jurisdiction dealing with Mr. Dick in regards to taking any wildlife outside of an Indian reservation. Let me be clear, if he is back here on something along these lines, we aren't going to be arguing it here. You can go up to the upper levels, and if you have an attorney, they can tell you how to do that. You can bypass me. You've been able to do it this entire time, but you keep refusing to have an attorney. Now you found one, as I understand it. It is very easy to bypass a justice of the peace on a jurisdictional issue, okay? An attorney knows how to do that.
You're not letting me speak.
No, I'm not, because I have already made my ruling. I'm trying to make a record here. So I'm also not letting the DA speak on these issues, okay?
I'm just trying to understand it.
What I want you to understand is if you're ever back here, you will not be allowed to raise a jurisdictional issue until and unless you get me overruled today, okay? As soon as I get the stuff, it will be denied immediately.
That's what this is all about right here.
I know. It will be denied. You've already put in
The
everything.
traditional tribal court is on federal lands.
It's denied. Okay? If you come back under these circumstances, none of that will be allowed to be argued.
That's what this whole case is about, sir.
I understand that. I'm telling you how you can go forward. You get hold of an attorney. It's not my place to tell you specifically how you go around me. You can, all right? You can get a ruling from a higher court before your case comes to trial. An attorney will know how to do that, all right? Now, in the future, if you want to raise that issue, you will have to do that. If you don't, it'll be very early, the case will be denied, and bringing it up will get you a contempt citation. And trust me, my jurisdiction is unquestioned for contempt of this court. There's only 3 groups of people that I know of that can get out from under a contempt citation from a court of any state or the United States. Those are congressmen and state legislators, okay, and diplomats. In the case of congressmen and state legislators, they have to be on their way to a legislative session. In the case of diplomats, they have diplomatic immunity. Other than that, everybody is subject to arrest, including the sheriff, including the DA, including my clerks, including me if there was a judge with the proper authority over me. Okay? No one is immune to that. You need to understand that. Now, all of that said, trying to think if there's anything else we have.
I'm supposed to have immunity
Mr.
with my
Dick.
trading.
I am not parlaying with you. We're done with that part of it. I'm just trying to make sure I'm covering everything in this case before we go to the next step. We have covered discovery. You asked for discovery late. The attempt to deliver it, you thwarted, so you're not entitled to complain about it. We have dealt with jurisdiction. I have jurisdiction. Can't think of any other preliminary things we need. Now, Ms. Elquist, my understanding is you have no witnesses, and you are not prepared to go forward today. Is that correct?
Your Honor, I don't have my witnesses here today because, in the name of justice, we weren't ready to go forward because the defendant has not been provided discovery to adequately prepare. Going on that, I would ask the court, or I guess check with the court, to make sure, because I haven't been present with the defendant, to make sure if he's going to represent himself or is he going to have a Nevada attorney.
Okay.
And if he's representing himself, to make sure there's been a proper Faretta canvas, to make sure he's fully aware of the dangers and disadvantages, and so going forward, we can adequately get discovery and move forward with this case.
All right.
And I would make the argument it's the defendant's fault of any sort of waiver of the preliminary hearing or the 15 days or the 60 days. I think there's a good argument that the waivers were, it's the defendant's fault that we have not progressed today to the trial and preliminary hearing.
Okay. First off, I realize you don't attend many, if any, arraignments.
Mm-hmm.
One of the things we do at arraignments is go through the rights of the defendant, including the right to counsel. I can assure you, and my staff will easily back me up, we have gone over it and over it. I have badly wanted Mr. Dick to ask for an attorney. He has refused, okay? It is not your place to decide what's reasonable in terms of discovery and so on. You merely have to abide with the requests when you get them. Our Constitution does not protect people who insist on doing stupid things. We have the freedom to do stupid things in this country, including to represent ourselves when we really don't know what we're doing. That has been upheld in cases where the defendants have been mentally unbalanced to some degree, but not enough, and where they've been more foolish even than Mr. Dick has been in this case. Therefore, I'm sorry, but I can't find that there was any legitimacy in your thinking that we weren't going forward today. The sheriff's office called me and asked yesterday if this was going forward, and I told them yes. I know of no communications to your office that indicated that we would not go forward. I am doing you one favor, since we have not sworn any witnesses and we're doing all of this preliminary stuff. You will be able to appeal this ruling. And boy, would I like somebody to appeal this ruling, because I would like some guidance from the higher court as to how they want to proceed. Because based on his history, and let me just recite some of that so that hopefully the upper court realizes he's coming back here. He is certain in his mind, I am convinced of that beyond any doubt, that he is all kinds of morally right. Okay? He thinks he has the total right to take antelope. And the only way we're going to stop him from doing that, if we're going to stop him from doing that, and if he's wrong, is by sheer force of power. Okay? The same way we stop communists or terrorists that believe firmly in what they do. All right? That's what the jails are for. That's what power is about. We try to argue with people and be kind to them and deal with them when they are reasonable and they're in general agreement with our way of doing things. But when they are not, the last resort is force. Okay? That is where we were at. We could have gone forward today, and I would have, notwithstanding all of that, because I believe Mr. Dick created his own problems. And I do mean this. We asked him every single time I've seen him, and more than once each time, whether he wanted an attorney, and it has been strongly suggested to him that he get an attorney, but he steadfastly refused. It was also strongly suggested to him repeatedly that he waive his speedy trial rights and his speedy rights to a preliminary examination. Those things are guaranteed by the United States Constitution. They are made binding upon the states by the 14th Amendment to the United States Constitution. And consequently, we have our statutes which say 15 days for preliminary exam and 60 days for a trial. He is at the very edge of that time on the trial, on the preliminary exam, because we did not get done the preliminary exam arraignment until last week. He's only a few days into it. But today was set a long time ago. I would advise the DA's office in the future, if you think something might go off, you need to call the court. If the court, any court, and any judge, whether it's me or Judge Bunch or some future judge, if they haven't said it's going off, you need to be prepared. Okay? Any attorney I know of would not have been able to do away with Mr. Diggs. I shouldn't say that. It's possible to do that. At any rate, I am going to rule that these cases are dismissed with prejudice for failure of the state to bring forth witnesses. And with that, is there anything else that we need to take care of here? Hearing nothing, court stands adjourned.